Hi, I'm Bill Kirshner, an Assistant General Counsel with the FLRA's Office of the General Counsel. In this series of videos, the Office of the General Counsel is providing training on collective bargaining, one of the most complex subjects under the Federal Service Labor Management Relations Statute. This series will cover what is included in the scope of bargaining, what represents good and bad faith bargaining, duty to bargain issues, including term, midterm, and an in-depth analysis into change bargaining, addressing both what is a change and what impact is necessary to support the finding of a bargaining obligation. What defenses exist that may modify the duty to bargain, including covered by, contract interpretation, and times when grievances, not ULP, should be pursued. And lastly, remedies when bargaining violations occur. You will soon see that collective bargaining is one of the most complex subjects under the statute. If you do not watch the entire series, you may miss critical information affecting your ability to successfully bargain. Why is bargaining so complex? It's complex because there are three broad factors simultaneously at play in bargaining cases: scope of bargaining, duty to bargain, and defenses to the duty to bargain. Let's explain what each of these mean. First, scope of bargaining addresses what topics are generally included or excluded in the matters a union may be entitled and an agency may be required to bargain. Second, duty to bargain sets out when the duty to bargain arises. Generally, this encompasses term, midterm, and change bargaining. Third, defenses to the duty to bargain need to be examined. Sometimes it appears a matter is within the scope and duty to bargain, but for one of several legal reasons, the union does not have a right and the agency does not have a statutory duty to bargain. To illustrate the interaction between these three concepts, we will revisit this diagram later. Additionally, concepts of good and bad faith bargaining and the ability to pursue negotiability appeals or grievances or to appeal to the Federal Service Impasses Panel can also impact pending unfair labor practice charges. Considering how many factors are in play, when parties approach each other with mutual respect and respect for the process, the likelihood of good faith bargaining improves. This series introduces terms and concepts the OGC will raise in investigations which help govern the FLRA in adjudicating bargaining disputes. It does not represent legal advice. Now, on to the presentation. If not for the statute, what would a federal union be entitled to bargain? And what would a federal agency be required to bargain? The answer is zero. Nothing. The only reason unions have a right and agencies have a duty to bargain is because the Federal Service Labor Management Relations Statute creates a duty to bargain. So let's see what the statute has to say about federal sector bargaining. In Section 7101, Congress found that labor organizations and collective bargaining in the civil service are in the public interest. And Section 7102 notes that employees' rights include the right to engage in collective bargaining with respect to conditions of employment. Let's return to our circle to explain what's within the scope of bargaining. We'll label the interior conditions of employment, which is what the statute says unions have a right to bargain about. The concept of conditions of employment is reinforced in Section 7103A12, which defines collective bargaining. As we discuss matters included in the scope of bargaining, it is worth noting this section reinforces a union's right to bargain over conditions of employment affecting employees. So the union gets to bargain about conditions of employment, shown here in green inside the circle. Matters not subject to negotiation are shown in red outside of the circle. So what are conditions of employment? The statute defines conditions of employment in Section 7103A14 as personnel policies, practices, and matters, whether established by rule, regulation, or otherwise, affecting working conditions. We will further examine these terms later, but first let's examine the three subsections. Subsection A states that the term conditions of employment does not include policies, practices, and matters relating to political activities. Subsection B excludes matters relating to classification. And subsection C notes matters specifically provided for by federal statute are removed from the definition of conditions of employment. Let's return to the circle chart and examine this more closely. Subsection A removes matters relating to political activities from bargaining, such as a federal employee using duty time or federal property for political activities. Theoretically, these activities could be subject to collective bargaining, but when Congress drafted the statute, it expressly removed this subject from bargaining. Instead, Congress passed the Hatch Act and removed this from the scope of bargaining. Subsection B removes matters relating to a job's OPM series and grade classification from bargaining. Make no mistake, the classification of a position as a GS-12 specialist or a GS-13 professional impacts a job's pay. But does a union have a right to negotiate over the job's series and grade? No, because subsection B removes this from the scope of bargaining. Instead, Congress created a classification review process, which is often run by the employer and includes a right to request an OPM desk audit. Subsection C removes from bargaining matters specifically provided for by federal statute. For most federal employees, this includes pay, pensions, insurance, annual and sick leave, travel and move benefits. So very much of the most important matters bargained in the private sector. These matters are removed from the bargaining table in the federal sector to the extent they are specifically provided for by federal statute. This concept is reinforced by Section 7117A, which states that the duty to bargain in good faith does not apply to matters conflicting with federal laws or government-wide rules or regulations. Of course, laws sometimes provide options. When agencies have discretion as to which options to adopt, the agency may have a duty to bargain over how it exercises that discretion. So, inside the circle are the matters a union gets to bargain about. If you are a party who wants to bargain, you want the circle to be as large as possible. Subsections A, B, and C reduce its size and take matters off the bargaining table. Up to this point, we have defined the circle by explaining what is not included in the scope of bargaining. Let's now try to fill in the circle by looking at authority case law, which explains statutory terms by applying them to real-world situations. The authority's lead case is Antilles Consolidated Education Association. In Antilles, the authority said in deciding whether a proposal involves a condition of employment of bargaining unit employees, the authority considers two basic factors. First, whether the matter proposed to be bargained pertains to bargaining unit employees, and second, the nature and extent of the effect of the matter proposed to be bargained on working conditions of those employees. This is known as the Antilles test, and it helps explain what is included in the scope of bargaining. At times, proposals impact both unit employees and non-unit employees, or even individuals who don't work for the federal government, such as customers, patients, or the public. Proposals that directly implicate non-employees are not within the scope of bargaining unless they vitally affect unit employees' working conditions. To further help us understand the green shaded area, we need to redirect our attention to Section 7103A14C. Subsection C has broad implications on the scope of bargaining, as many matters are provided for by other laws outside the statute, such as those removing pay and pensions from the bargaining table. Subsection C often points outward to other laws and regulations, but also can point inward towards other parts of the statute. Looking inward, one critical part of the statute impacting bargaining is Section 7106. Section 7106 is a common source of confusion and uncertainty by agencies and unions. As we study this section, we'll examine these issues. Section 7106 is titled Management Rights. Looking at its construction, it has an A section and a B section. And the section's very first sentence states, all of A is subject to B. That means the exercise of any and all A rights are subject to Section 7106B, which we will discuss after we look at A more closely. Section 7106A lists management rights, which expressly include the right to hire, fire, assign, suspend, remove, to determine the mission, budget, organization, number of employees, internal security practices, to lay off, to name just a few. It is a very broad list that, in toto, represents management being management. This section is also the source of a common agency unfair labor practice. Some agencies have asserted that the union has no role whenever Section 7106A rights are being exercised. However, the statute says A is subject to B. If A didn't start with a clause subject to B, there would be much less bargaining in the federal government. However, A is subject to B, And that means we need to look at B when management exercises its 7106A management rights. So, let's turn to Section 7106B. Structurally, there is a B1, a B2, and a B3. B1 starts off with the clause at the election of the agency. Traditionally, that has meant that agencies could bargain B1 proposals and matters if they want, but if they didn't want to, they didn't have to. This is called permissive bargaining, which means bargaining over these matters traditionally has been at the election of the agency. By the way, once parties sign a B1 agreement, it is a fully enforceable collective bargaining agreement. But until it is agreed upon, the agency traditionally has had the right to, on elect, to bargain over B1 matters. Now, B2 and B3 do not start with the clause at the election of the agency. As a result, these two provisions are not permissive. Instead, B2 and B3 bargaining is mandatory. These two provisions authorize bargaining over procedures and appropriate arrangements for adversely affected employees, which we typically call impact and implementation bargaining. B2 and B3 bargaining represents the bulk of bargaining that occurs in the federal government. B2 and B3 bargaining is not over the substance of the decision to exercise a 7106A management right, like conducting a reduction in force, but instead is over the appropriate arrangements and procedures for adversely affected employees, such as when the reduction in force will occur or how impacted employees will be given training or priority rehiring rights. When bargaining is over a 7106A management right, shaded in yellow, the union's proposals must be appropriate arrangements or procedures. Before examining appropriate arrangements and procedures proposals further, let's look at the green shaded area, which includes matters that are not about 7106A management rights. These matters are substantively bargainable, meaning the union has the right to bargain on whether the matter will be implemented at all. Matters are substantively bargainable because they do not impact Section 7106A management rights. Examples of these include alternative work schedules, official time, union office space, access to agency equipment, and traditionally, parking. For example, if the elimination of parking spaces next to a building is linked to a 7106A management right, like security, a union may be limited to B2 and B3 bargaining. But if 7106A management rights are not involved, the union may have a right to bargain substantively before the change is implemented, meaning a union can propose the parking lot remain unchanged. However, most proposals impact 7106A management rights and thus need to address the procedures, such as the timing, or be an appropriate arrangement lessening the impact on affected employees. These proposals are negotiable as long as they do not excessively interfere with management's exercise of its 7106A right. The authority has noted union proposals that excessively interfere with the exercise of management rights do not have to be bargained. Said another way, if a union's proposals only go to the substance of whether a matter will be implemented, when the union is entitled only to bargain the impact and implementation, the proposals are non-negotiable. And as we will later see, if a union fails to submit any negotiable proposals, management may assert the union waived its right to bargain and implement. In summary, an agency citing a 7106A management right as a basis for refusing to bargain appropriate arrangements and procedures proposals may be committing an unfair labor practice, and a union submitting proposals that are not appropriate arrangements or procedures may waive its right to bargain. So what makes a proposal an appropriate arrangement? The authority employs a balancing test, weighing the benefits to the employees under the arrangement against the intrusion on the exercise of the management right. To be an appropriate arrangement, the proposal must be an arrangement for employees affected by the exercise of the management right and be sufficiently tailored to compensate or benefit employees suffering adverse effects attributable to the exercise of the management right. The authority asks, is the arrangement appropriate, or does it excessively interfere with management rights? Authority case law further notes that the proposal must seek to mitigate the adverse effects flowing from the exercise of a protected management right, and the proposal must be tailored so as to provide the balm only to the hurts arising from the exercise of the management right. The proposal may not be so broad and sweep that the balm would be applied to employees indiscriminately without regard to whether the group as a whole is likely to suffer adverse effects as a consequence of management action. One last concept to convey. The impact on unit employees need not be negative, and the union may have a right to bargain B2 and B3 even if a new benefit is offered to unit employees. This concludes the first video on collective bargaining describing topics included in the scope of bargaining. Remember, even if a matter is within the scope of bargaining, we also must determine if an agency has a duty to bargain at that time. Additionally, we must determine if an agency can assert a defense to the duty to bargain, all of which means an agency is not required to bargain over all matters within the scope of bargaining. The videos on the duty to bargain and defenses to the duty to bargain include material impacting determinations about bargaining in different situations. For more information, visit us online. And as always, feel free to contact the FLRA for assistance.